My lords, my lady, I'm going to pick the baton up now on ground one for EE, and I'm going to address the court on phones for use allegations as regards what Mr Swanty did or didn't do at the landmark lunch. Right. And I'm then going to pass on to ground two, and then hand the baton back after that to Mr Hoskins again for O2 to finish up on ground two. Okay. Before doing that, I would like to say a few introductory words. So the appellant's advocates have, with their usual skill, managed to stitch together much to say on this appeal, and it is cleverly and it is appealingly put. But the reality is this. Mr Justice Roth's judgment is a highly careful, conscientious and detailed examination of the matters raised by the parties in a long and hard-fought trial. Now, of course, in a case such as this, the appellants can point to findings with which they disagree or that they feel hard done by. But on proper inspection, we say that phones for use appeal consists to a large degree in illegitimate factual quarrels that are dressed up as points of law, and where they are real points of law, they're wrong. Now, a problem this court will be, I'm sure, alive to when considering this appeal is that we are spending 1 week with exceptionally skewed attention scrutinising the details of certain aspects of the evidence that phones for you would like us to focus on. The judge, of course, had the advantage of hearing 45 witnesses in a 10-week trial, and he had thousands of contemporaneous documents available to him, which he carefully reviewed where they were relevant. And he was able to see whether the alleged timelines and motivations stacked up in the light of all of that evidence. And I say it's important to keep that in mind, because phones for use submissions repeatedly ignore swathes of relevant materials, and it acts as if much of the trial didn't in fact occur. Now, at the beginning of the trial, before the High Court, Phones for You argued that it would be so irrational for any mobile network operator defendant to decide individually that it was in its own interest to leave Phones for You, that such a decision could only be the result of coordination. That was their case. It was, as they called it then, the prisoner's dilemma. Now, by the end of trial, they had essentially given up on that case because the expert evidence in support of it didn't hold up, and it was rejected in any event by the court. For your reference only, that's judgment 634. And what the judge found is this. He found that whilst when there were 3 major MNOs, they would obviously be alive to the risk of losing share if they exited Phones for You. That didn't preclude them from doing so. It was just one factor amongst many to be weighed in the balance as to whether it was a commercially sensible decision. So the dilemma didn't in fact make unilateral departure irrational. Indeed, by the time it was just Vodafone and EE left in Phones for You, the court found in unchallenged findings that far from there being a prisoner's dilemma, Vodafone and EE each had solid commercial reasons for keeping their strategies very much to themselves, because they both wanted to avoid becoming the last man standing in a weakened Phones for You. So the last thing they wanted to do was give away their strategy for fear that their rival might make a move on them first. So what that left, and I say leaves before this court, is a case that notwithstanding it was rational for the operators to take the individual decisions they did, they nonetheless decided to collude. Now I say, in addition to being commercially implausible, that would have involved a secret conspiracy amongst in the order of 20 or so senior executives, all of whom signed up to the conspiracy to make it work, and all of whom lied about it on cross-examination. And it would also have involved each defendant being involved in a quite extraordinary and sophisticated cover-up, falsifying the record in their internal presentations, their internal emails, their modelling, their records of meetings. Because they clearly show that each of the MNOs did not know what the others were about to do. They obviously tried to guess, and in EE's case, it quite often got it wrong. So in my submission, the overwhelming balance of the evidence, including very large numbers of contemporaneous materials that were before the High Court, was inconsistent with Phones for Use implausible case. It showed as follows, that the reason why the network operators progressively left Phones for You, albeit over a number of years, and in each case driven by their own individual decision-making, was that they felt that Phones for You was becoming an increasingly unattractive commercial partner, and Carphone Warehouse a more attractive one. Now, what had happened is that Phones for You's owners, BC Partners, had extracted huge amounts of cash from the firm, and as a result, Phones for You needed a bigger cut from the MNOs than its rival, Carphone, in order to be profitable. And so it became unable to offer as attractive terms to the MNOs as its rival. That's Judgment 313. Carphone also outmaneuvered Phones for You in its merger deal with Dixon's. So at the same time as Phones for You was offering less attractive commercial terms than Carphone, it was simultaneously becoming less commercially relevant. Now, as regards the allegations of collusion between EE and O2, the meeting, of course, is the landmark lunch. It was one which EE openly pleaded in its defence. Phones for You didn't even know about it or originally allege it. The reason why it came into trial was because we chose to plead it. Now, whatever Mr. Dunn might or might not have wanted to happen, it never went anywhere for the two reasons that Mr. Hoskins outlined, and the first of which he expanded upon. First, because Mr. Dunn's remarks were wholly vague, and so they didn't substantially reduce uncertainty as to what it was actually liable to do. That's the first link in the chain. And second, and in any event, Mr. Swanty simply didn't engage with them. The second link in the chain. And so crucially, there was no consensus. And yet proving consensus is an integral aspect of proving consultation, as Phones for You indeed admit at paragraph 17 of their supplementary skeleton. So what the court has heard, of course, is that Mr. Swanty was sufficiently nervous about what Mr. Dunn might be saying. He started to record the conversation. He went to his GC, and they then sought legal advice from Slaughter and May, on which they acted. Now we say those are just not the actions of a party engaging in anti-competitive collusion over their future actions on the market. And moreover, far from subsequently pulling back from Phones for You, which is what we may infer Mr. Dunn was ultimately hoping to get from the meeting, EE did quite the opposite. It renewed its contract, and when O2 did ultimately leave Phones for You, EE went in and took up even more volumes. So that's the summary of the position in relation to EE and O2. And then as regards EE and Vodafone, the alleged coordination there is said to have taken place in particular as between EE's parents, Deutsche Telekom and Orange on the one hand, and Vodafone UK or Vodafone Group on the other. Now, the contemporaneous evidence shows that coordination between Vodafone and EE or its parents never happened. That the theory does not stack up for a host of reasons. And one of them is this. the central allegation that Phones for You make is that Vodafone shared its strategy with, in particular, Orange in April 2014. But the problem with that is that occurred at a time when Vodafone didn't even know what its own strategy was going to be. And nor, for that matter, did EE know what its strategy was going to be. That's judgment 576. Second, the contemporaneous evidence shows that EE's best guess as to what it thought Vodafone was likely to do was to stick with Phones for You, which is the opposite of the strategy that Phones for You says had been shared with EE, and that's judgment 585. And then thirdly, EE's modelling, which we'll be coming to probably on Friday, was contrary to what Phones for You says, premised on Vodafone staying with Phones for You. So, in summary then, my submission is that this claim was and is a huge £100 million punt by Phones for You's administrators to see if they could pin its demise on the mobile phone operators. And it failed. The judge ultimately made no appealable errors, and sending this case back for retrial would, in my respectful submission, be a vast and unjustified waste of costs. So, if I may then turn to the meat of round one. The bottom line here is that Phones for You's appeal fails on ground one because it comes up hard against the factual findings that it claims not to be appealing. And set against those factual findings, its so-called points of law don't go anywhere. They are, in reality, just impermissible factual quarrels. Now, Mr. Hoskins has obviously covered the first link, which is the communications from 002 to EE, and whether they met the test of substantially reducing or removing uncertainty in EE as to 0.2's strategic moves in indirect distribution. So I'm then going to deal now with what EE did. But just before getting into the detail of that, it is worth just making one comment on the issue that Mr. Hoskins covered. When he took the court, for instance, to paragraphs 196 and 197 of the judgment, and there was an exchange about what it means for there to be an anti-competitive approach. Because Phones for You say, look, it was an anti-competitive approach. It's what Mr. Dunn wanted to get out of the thing. That's why he was doing it. And what we say is that Phones for You has elided two different meanings of the phrase anti-competitive approach. There is a colloquial meaning, and then there is a technical meaning. So an approach can be anti-competitive in the sense of indicating a generalised willingness to engage in something anti-competitive. I call that getting to base one. Or it can go further and constitute the conveyance of strategic information, substantially removing uncertainty as to future strategy on the market. And that's base two. And it's the second of those that is needed as the first essential ingredient for a concerted practice. So consider this example. If someone says, I'm interested in doing something anti-competitive if you are. Those are the literal words. Now, that's an example of an anti-competitive approach in the first colloquial, generalised sense. But it is, and it's obviously not a good thing to do, but it isn't the first necessary ingredient for a finding of consultation, or indeed it's extremely unlikely to be.
Well, it could be in certain circumstances,
well,
depending on the background.
Perhaps it might, I mean, obviously, if we read in lots of context and we know that the moment those words are spoken,
referring to
exactly, if we know that the words that Moses are spoken to exactly what they actually really mean, then it might be. But removed of any context to give us that, the pure fact that you say, I'm interested in doing something unlawful if you are, does as misguided and as improper as it might be, on its own, it doesn't supply the first necessary ingredient. And that, in my submission, is the key to unlocking the submissions that were made by Mr. McLean when he talked about anti-competitive approaches. Of course, it's an anti-competitive approach, so therefore there was, naturally anything that followed from that was collusion. That's wrong. It doesn't reflect the law that Mr. Hoskins very carefully took me through before the short adjournment. So that's my submission on that point. And
the only evidence other than recollection 10 years after the event, which we have, is the email, isn't it, from Blandis?
That's right. And indeed, we don't have this...
Because the email because the iPad's gone missing,
yeah.
The transcript's gone missing.
Yeah.
If Slaughter's ever had a copy of the transcript, they can't find it.
Yeah.
So all we got is the email.
That's correct. That's correct. And indeed, it was common ground at trial. We don't have it in the bundle, I'm afraid, but it was common ground between me and my learned friend that was the best contemporaneous evidence. That was in fact Mr. McLean's submission.
Yeah.
Yes. And Mr. Williams reminds me, of course, that in seeking to be as helpful as we could to the court, we waived privilege in relation to
this.
this.
I understood.
Because we believed we had nothing to hide, and we were going to provide the best that we could. So it was unfortunate that some things 10 years later were not still there, but we did our best, and we waived privilege, and we provided everything, including that email. So yes, that is the best evidence. And if I could then pick up the factual findings that the judge made, so to continue the story from where Mr. Hoskins left it off,
yep.
If we could pick up their judgment, please, at paragraph 200, which is on page 318 of the judgment bundle. And if I could ask the court please to read paragraph 200.
Mm-hmm.
So, very clear, factual finding. Mr. Swanty did absolutely nothing to give encouragement to Mr. Dunn or to suggest that in any way EE was willing to go along with what Mr. Dunn might have been suggesting. And then we saw paragraph 208. Mr. Hoskins took us to that. And then the next key finding is at 217. Mr. Hoskins took us to part of that, but there's another part that I'd like to emphasise. So the final sentence, I've concluded that the remarks were too, so this is talking about Mr. Dunn's remarks, were too vague to remove uncertainty in EE as to O2's future conduct, and I do not think that the circumstances were such that Mr. Dunn could have inferred from Mr. Swanty's silence any form of acquiescence or consensus to cooperate. So another core factual finding. Mm-hmm. And then at 229, so this 229, now this is a section dealing with public distancing. But in the first sentence, although while I consider Mr Swanty was genuinely shocked by what Mr Dunn was saying, and absolutely opposed to any anti-competitive advance or approach from O2. That's the point that I wish to emphasise. He then goes on to say he didn't do enough if it were required, or EE didn't do enough if it were required, to engage in public distancing. But nonetheless, the finding of fact there, the first part of that, is clear. And then at 232, last sentence, as I found that Mr Swanty made no disclosure to Mr Dunn of EE's position, nor did he offer to give any support from EE for O2 strategy, I don't see any scope for the Anic presumption to apply as regards O2. And then there are further findings in relation to what O2 could possibly have taken from what Mr Swanty said, i.e. nothing, in 234. You were taken to them before. The court might just like to very briefly remind itself of them. So what I say is that these contain critical findings of fact as regards EE's conduct, which Phones for You claims not to be challenging. In none of those passages was the judge making the point, as Phones for You at least sometimes seems to suggest, that as a matter of law, consultation can never be inferred from silence. Of course he wasn't saying that. The judge is simply making findings that on the facts as he found them, there was nothing to infer from EE's silence in this case. So if you take Mr Dunn's wholly vague suggestion and you add to that Mr Swanty's silence, that does not equal EE accepting strategic information from O2 as part of a consensus. And
well, the classic example of silence, where silence can amount to a consensus or consultation, is where there are a whole load of people at some meeting. One of them doesn't actually say anything, but he nonetheless stays at the meeting, during the course of which other people are saying things that they shouldn't be saying.
Well, that's quite. it's a good example of what you shouldn't do.
Yes.
In my submission, it's actually slightly different, and the reason is this: most of that case law about being in meetings and staying silent, and then being fixed with something that happened, that derives, at least initially, from cases where there's a cartel and there's a cartel agreement. And so the classic example of that case, which we see repeated in the case, and indeed I'm going to be coming on to this when I deal with some of the legal points, is you have A and B, and they conclude an agreement. And C is sitting there and says nothing. And C, because there is a complete anti-competitive act that has crystallised, C gets stuck with that.
It's a cartel situation.
Yes.
That wouldn't necessarily be limited to an agreement, but if it was clear that there was a concerted practice between A and B, the same point.
So I do accept that. I accept that. That really, in my submission, actually just it applies by analogy.
But the point is there is some sort of agreement or concerted practice going on.
Yes.
And the issue is who's a party to it, as I understand.
Exactly. Because of course and I'm going to come back to this when I deal with the legal issues, but anticipating what I'm going to be saying a little bit. One of the implications of the way that Mr McLean puts his case is that you're always stuck if you're silent. So you've got to engage in public distancing. And the submission that I'm going to be making on that is wrong, because public distancing comes into the picture if something has already crystallised which you need to publicly distance yourself from, i.e. there is an agreement or there is consultation. But it isn't a necessary ingredient for avoiding consultation in the first place. I'm going to come back to make that good, but that hopefully is, at least in part, an answer to your ladyship's point. So I noted, obviously, the concerns of my Lord Chancellor in relation to the consistency of the various factual findings. Mr Hoskins addressed those in part, certainly from O2's perspective, in relation to paragraph 225. That's the paragraph that deals with the fact that Mr Dunn came back later and was interested in collusion in relation to Apple. I don't think we need to go to it again because we've been to it many times. But I'm happy to remind you we're in the judgment, so why don't we just go back a couple of pages to 225. So what's happening in this context is the judge is making findings where he is analysing whether EE engaged sufficiently in public distancing. Contrary, of course, to his primary case, that there was no consultation, and therefore if there was no consultation, there was no need for any public distancing. Or his primary finding, and our primary case. And he refers to Mr Dunn being willing to try a second inappropriate approach on a different issue. But the finding here, we say, is entirely consistent with what he said previously. Because what he's saying is that Mr Swanty's silence may well not have put off the irrepressible Mr Dunn from a later attempt to collude on a different topic, but that doesn't mean that he indicated acquiescence in cooperating in relation to indirect distribution, which was what Mr Dunn was interested in at the landmark lunch. So what Mr Dunn, we infer, wanted, and indeed he needed from that lunch, was some reassurance that if Phones for You played a big card, EE wasn't going to respond in some way that was detrimental to O2 by going in and taking up that volume. That was what that was about. And he simply didn't get that. He didn't get that at all because Mr Swanty gave no indication of what EE planned to do at all. And so what we have here is a situation where, well, he thinks, okay, well, that didn't work, but I didn't get the red card, or also described as the red light by Mr McLean. So how about this? I'm not going to give Apple. I'm going to give that issue a go. But that's a different issue, and it doesn't undermine what the judge's findings were in relation to the indirect distribution issue, which is what this trial is about.
Much might turn on what the judge meant by wholly uninterested there. Is it, I'm not totally uninterested in anti-competitive approaches because I haven't told you
Yes.
not to make them?
Yes.
Or, which I think is Phones for You's case, it's effectively saying, I'm rather interested in this idea you're conveying to me.
Well, I say it's the former for two reasons. Firstly, because naturally one reads the judgment as a coherent whole, and the natural understanding of what the judge is saying here is to be read in context and in the light of his other findings. Secondly, because it is elucidated by the next sentence, because what the next sentence does is it goes on to explain. If he had felt that Mr Swanty was clearly opposed to any kind of anti-competitive exchange, Mr Dunn would hardly have caught him some weeks later seeking to exchange confidential information regarding their company's negotiations with Apple. So I say that also informs our understanding of the first sentence, and is the second ingredient in my answer to your ladyship's question. And
well, I have to say, speaking for myself, I find 225 one of the most difficult paragraphs in the whole judgment, because it does seem to me, despite the valiant attempts to pass it, which you both, you and Mr Hoskins have made, I find it very difficult to read it as being anything other than a finding that's completely inconsistent with his earlier findings. Because it just seems to me, I mean, true it is, it's looking at, as it were, whether or not Mr Swanty's totally opposed to anti-competitive conduct generally. But the specific context is anti-competitive conduct, or a proposed, an invitation to collude in relation to, as it were, reducing the indirects to dust, which the judges held Mr Swanty understood. So this isn't to do with what, and the fact that he comes back later, the judge is saying, well, the reason he comes back later is because he's got the impression that Mr Swanty's not opposed to anti-competitive approaches.
yes, and in
The previous context being an anti-competitive approach about indirects.
and
Very difficult to follow.
well, I think everyone agrees it's not the easiest paragraph to parse. But my answer, my lord, to your lordship's question is, in fact, it somewhat comes back to what I was saying before about the two different meanings that one can ascribe to the phrase anti-competitive approach. And the point is, when the judge makes his initial findings about what happened at the landmark lunch, he is accepting that there is an anti-competitive approach in the first sense, the getting to base one sense, as in indicating a willingness to do something that you shouldn't. And so what he's saying is, Mr Dunn indicated a willingness to do something that he shouldn't, and he didn't get slapped down for that. And so therefore he thought, well, maybe I can give that another go. But what Mr Dunn didn't get so far as to do was to convey sufficient information that he was giving away O2's strategy in relation to indirect. And in my submission, that's the answer to the conundrum here, which is that whilst the judge found that because of the absence of the red light or the slapping down, there was still some scope for Mr Dunn to feel that he wasn't necessarily in totally arid ground, coming back for another go about a different topic. Nonetheless, on his first topic, he never made the headway that he perhaps had been hoping that he would make. Because presumably, I mean, this is obviously inference, but I think this is fairly natural inference. What he was doing initially was sending out some feelers, as one might do if one is seeking to engage in something that he shouldn't have been. Step one, see if there seems to be some interest. If there's no interest coming back from the other party, well then you don't go on and proceed to step two and reveal the nature of what you're trying to do, because it's a delicate flirtation, effectively.
Well, I find that very difficult. I mean, I understand that, but I find that very difficult to square with 197 for starters.
Yes, I mean,
he's not saying that Mr Dunn approached it in two stages. What he's saying is Mr Dunn may not have... I mean, true it is he makes findings elsewhere that it was all too vague,
yes,
but they do seem to be inconsistent with those the last two sentences of 197.
He made sufficient headway to get across
what it was he was trying to get across.
Well, what I say is he makes sufficient headway to get across something that takes you to base one, he doesn't make sufficient headway to get across what gave away strategic information about what phones for you, O2 were actually going to do. Because and again, it's important, and this is very difficult, obviously, in the context of this hearing, because this court actually doesn't have the whole of the context. But in indirect distribution, we're not talking merely about what O2 or EE might do as regards phones for you. For start, we obviously know there's car phone warehouse. There are other indirect distributors. There are questions about how much volume one might put through different distributors. There are questions about whether you might stay with a particular distributor or not. Those are all different strategic questions. It was known to all the MNOs, I think it's paragraphs 197 to 203 of the judgment. It was common knowledge that none of them really liked the situation. So it was common knowledge that all else equal, they would be preferring to reduce their reliance on indirect distribution. And so in that context, what I say is that Mr. Dunn never got far enough to actually give away anything of sufficient strategic value, because he wasn't sufficiently specific about what it is that O2 were actually thinking of doing.
But you also say that even if he did, there's nothing coming back the other way to amount to.
Absolutely. So yes.
That's Mr. Hoskins.
Exactly. I've obviously strayed into Mr. Hoskins' territory, but I'm seeking obviously to assist the court in relation to that.
But it isn't his finding in relation to nothing coming back the other way, effectively the other side of the same coin, because isn't he saying because nothing was coming of any specificity, you couldn't say that anything came from Mr. Swanty, because there was nothing coming to him that he could acquiesce in.
Yeah, well, it's certainly related. So I certainly say that one has to understand the lack of content in the silence going from Swanty back to Dunn in the context of the vagueness of what Dunn said to Swanty. So I certainly agree with that way of putting it.
Well, isn't that what the judge is saying at the end of 217?
Yes.
As I understand it, what he then goes on to do is to say, well, look, if I'm wrong about that, and effectively what was being said wasn't too vague, and so you can infer acquiescence, was there public distancing?
Yes. And
in that regard, he's saying, well, you can't, because, for the reasons he gives, 224 and 225.
I respectfully agree with that.
But that means the key point on really all comes back to the vagueness of the information.
Well, it certainly is a key point. The reason why I said that I agreed with one way of putting it was because what I wouldn't agree with is the following, and this may well not be what my dog was suggesting, but what I wouldn't agree with is that it all hangs by that thread, because because what consultation requires is consensus, and so it is quite possible, and indeed in my submission there are findings in the judgment that support this, that even if the judge was in some way wrong about the specificity of the information that was conveyed by Dunn to Swanty, if in the context Swanty still just said absolutely nothing and gave nothing away, then it is still quite possible for there not to be consensus. And indeed that is what we say is...
And that's the point of law, isn't it?
Yes.
That we were addressed on by Mr. Claimant.
Yes, so that's why I was cautious in my response, because although I agree as a matter of fact, these two elements are heavily interrelated, which is why I've inevitably got dragged back into dealing with the first one. As a matter of law, there are two things that have to be shown: both the initial conveyance of the information. Secondly, either it was asked for, and there's no suggestion by Phones for You that it was asked for, or that it was accepted, i.e. there was some sort of consensus in relation to it. And I say that that is also absent. So both of those points are ones that I strongly maintain. And the second survives, even if the first doesn't.
But that's the point of law that you're going to come on to.
Yes.
That's to some extent why I'm not sure it's right to say that this is entirely a matter, that this challenge is entirely to fact, which I think is how you opened it to us.
Well, I mean, the reason why I would say it's a challenge to the facts is because I say if you look at the factual findings and you don't seek to unpick those, and Phones for You isn't allowed to under this grade, you don't have the essential ingredients, because first factual finding is too vague.
Yeah, that's Mr. Hoskins' point.
Yes. So
I'm looking at your point.
Okay. So the second factual finding is the ones that I showed you at paragraphs 200, also the end of 217, I think, which is, and in any event, Mr. Swanty gave nothing back. There was no consensus, and that's a factual finding. And so if you take that factual finding and you apply the law to it, again, we say this point dies. It dies.
That's your second point. That's your second.
Yes. So the answer to my Lord Justice Phillips' question about, well, why do I say it's basically just a challenge to the facts? Because I say that in reality, what Mr. McLean is seeking to do is wriggling out from those facts. Because if you actually hold his feet to the fire of the facts and you apply the law, and I'm going to come on just in very shortly to deal with what I say are the few legal issues, you get very quickly to the answer that there was no consultation because there was no consensus. That's my part of the case. So, in relation to the law, then, in my submission, there are three different legal points that I need to grapple with. And the last two are heavily interrelated. The first is Phones for You's claim, where they say the judge overstated the test for consultation by requiring positive support or an agreement to cooperate or a quasi-agreement. Now, I have 2 points to make in response to that, which I'm going to expand on. First, it disregards key parts of the judge's findings in the judgment. And second, it misrepresents the judge's findings in the permission judgment. So firstly, dealing with the judgment, what the judge found is that consultation requires consensus to cooperate. If I could please ask the court to turn to page 280 of the judgment, paragraph 77.
Yeah. Yes.
It's axiomatic that the expression agreements between undertakings in Article 1011 does not require a binding legal agreement, but will cover an informal arrangement between at least two undertakings that involves a concurrence of wills between them, expressing their joint intention. Moreover, the terms agreements between undertakings and concerted practices may overlap. The meaning of concerted practices and the applicable legal principles have been set out and developed in a number of judgments. And then the court quotes from Argos, and in particular, it's paragraph 21.5 that's of relevance here. Although the concept of a concerted practice implies the existence of reciprocal contacts, the requirement may be met where one competitor discloses its future intentions or conduct on the market to another when the latter requests it, or at the very least, accepts it. So that's the beginnings of the idea of consensus. And then that theme...
What does that mean, though? And does Is that the cement case that they refer to?
Yes, it's exactly. It's the cement.
It's all part of the long cement battle, I think, isn't it?
Yes.
But I mean, obviously, requests is understood.
Yes.
But accepts it is more sort of.
It is, and it's.
I mean, if somebody conveys confidential information about their strategy in a meeting, and the other party simply, as it were, soaks it up and doesn't object, is that accepting it? I don't know. It seems to me, on one view, it might be.
My submission is it's going to depend on the context.
Well, I was about to say, what you're going to say is it all depends on the facts.
Yes. Yes. So to give a really clear example where you can be sitting there silent, soaking it up and accepting it, is the Tate and Lyle case, which Mr. McLean took the court to. I think it was Monday. It might have been yesterday.
Yeah.
And in that case, one manufacturer, Tate and I think I'm getting this right way around. Tate and Lyle went to 19 meetings where its rival announced its strategy and its pricing strategy, and it kept going back and back. And what the court said in relation to that, understandably, is, well, given that you kept returning, you knew what was going to happen, you kept going back to the meetings again and again, you clearly were accepting that information, and therefore there was a collusive contract, there was consensus. So that's a classic example, but that's not our facts, and I'm going to come on to explain why on our facts.
Does that Roman 4 in Argos help more? I mean, the judge uses this expression, concurrence of wills and the party's intention. They've got to be idem in some way.
Yes.
That if that's the key point, I can see what you're saying. I agree that the word accepts is a bit more difficult.
The equivocal, isn't it?
Well, I entirely adopt that, and I was going to come on to a related part of Argos, which the judge quotes a little later on in the judgment, but it's making basically the same point. I think it would be helpful to go on to look at that as well. So, if we could go, please, to page 3, so paragraph 213 and following of the judgment. So that starts on page 322.
Yeah.
So
this is a jurist.
Yes, exactly. So the judge makes the point about context being critical. He then in 214 summarises the facts in Aturas, which we already know about. Perhaps one key point to make here, though, in passing, is Aturas wasn't a case of pure information exchange. I think, as my lady pointed out on Monday, what happened in that case is the communicating party actually amended the booking system that all the recipients used. So if the recipient kept on using the booking system, they were taking part in the very thing that was the anti-competitive concern. And so what we then get in the judgment of Mr Justice Roth is he goes on to set out the findings in Aturas 44, final sentence. Depending on the referring court's assessment of the evidence, a travel agency may be presumed to have participated in that consultation if it was aware of the content of the message. But critically there's a may, and there's a depending on the referring court's assessment of the evidence. So this is a context-specific, factual issue. And then there's a very helpful passage in the opinion of the Advocate General, which the judge goes on to quote at 215. And if I could ask, please, the court to read the whole of that from 46 of the opinion through to 49. So
that passage wasn't approved by the CJU.
It was not explicitly endorsed by the CJU, no. But one does, in my submission, it's consistent with the sentence in paragraph 44 that I showed the court. And probably the key point, key paragraph in that opinion, is 48, that the possibility of inferring tacit approval and therefore of establishing the existence of a consensus to cooperate rather than compete depends on the context of the communication. I would say that is almost a statement of the obvious. It inevitably is going to depend on the context, as the Chancellor rightly pointed out to me when I gave my example of are you interested in colluding? The Chancellor rightly said, well, it depends on the context as to whether that would or wouldn't be collusion.
Yeah.
So it's a context-specific, fact-specific exercise. And in terms of the way that the judge set up the legal test in the judgment, I say there's nothing there to criticise. So the second point then to make is, well, where do phones for you identify their error? They have to go to the permission judgment, not the judgment itself. We find that at tab 19, so it's the next, I think it's the next volume of the core,
yeah.
And it's at page 469. So, paragraph 22, in the specific context in which the landmark lunch took place, I found that Mr Dunn would not have inferred any encouragement or cooperation from Mr Swanty's silence, 217. Again, I think that is a factual finding on the evidence, which is open to the trial judge, and that there is no real prospect of the Court of Appeal finding that it was erroneous. Phones for you seek to cast doubt on that finding by reference to what I said at 225. But there, I was indicating that I did not think that Mr Dunn was given the impression that Mr Swanty was objecting or wholly uninterested. That is entirely consistent with the finding that he did not think that Mr Swanty was positively supporting the course of action O2 wished to pursue, or that his silence implied an agreement to cooperate. Now, what is said about this by Phones for You is, well, there you go, he's overstated the test because he mentions positively supporting the course of action. But the point here is the judge is not setting out the legal test here. He is explaining two factual findings that he made and why they are consistent with one another. So it is entirely true that he makes both of these factual findings, and his factual findings in relation to Mr Dunn and Mr Swanty's exchange relate to the particular circumstances of what was being considered there. Because, of course, what Mr Dunn needed in that context was some sort of support. That's not saying that in every single case the test is, do you need, that it has to be positive support. But in the context of what was happening between Mr Dunn and Mr Swanty, what Mr Dunn wanted was some support from Mr Swanty for his initiative, which is...
Well, specifically, he wanted some indication that EE wouldn't go along and hoover up the capacity.
Exactly.
And one way in which Mr Swanty may not have been wholly uninterested was he might be thinking, we'll do just that. As in hoover up the capacity. That's one of a range of possibilities.
Yes, and in that world, given that is one of the possibilities, and indeed ultimately what EE did was the opposite of what Mr...
Well, it did precisely what I've just said.
Yeah, exactly. Exactly. Then given that was a possibility that was open at that point, Mr Dunn was in no position to walk away from that meeting thinking, oh, well, I've now got the comfort I need. So there was no consensus, which is a context-specific issue.
Yeah.
So the next two related points on the law on this ground, I can hopefully.
I mean, if it's right that what the judge found at 225 is falls short of what's necessary for the purposes of consultation, which I think was Mr. Hopkins' submission earlier, then I follow all of that.
Yep.
But the difficulty I had was that it was in reconciling 225 with some of the earlier findings. But I mean, I think what you're really saying is it's no more than Mr. Swanty is not in effect saying, go away, I don't want anything to do with you, never darken my door again. Mr. Dunn thinks to himself, well, maybe this chap's not entirely resistant to another approach on another related topic, and I'll have a go at that in a couple of weeks' time. I mean, that maybe it's no more than that.
That is my submission. Yes.
Okay.
So that then takes me to the second way that I apprehend that Phones for You are putting their argument.
Yeah.
Which is which to some degree I've already foreshadowed.
Yes.
They seem to be saying that in every case where party A says something to party B, which may have an anti-competitive flavour, there is without more consultation at that point if there's merely silence. I think that's what they're essentially saying. That if they get over the at least the obstacle of the first element, that is that it sufficiently reduced uncertainty in terms of the communication from A to B. If what B does at that point is stay silent, then there's a rule of law that they're stuck, that there is consensus.
Well, that was said very clearly, Mr. McLean. He said there was only one permissible response.
Yes, which is public distancing, and that's his case. And I say that is too simplistic, because it would have the effect of denuding the concept of consensus of any meaning. Because of course there may be some contexts in which silence is enough, and I gave the example of the Tate and Lyle case. But it isn't going to be sufficient in every case, and indeed there's an illogicality in Mr. McLean's submission, because under pressure from the bench he was forced to concede that actually his rule is not quite as absolute as he suggests, because he considered that in Eturas there wasn't such a strict rule, that in some contexts silence might not be enough. And in my submission, that chink is ultimately the logical end of his case on this, because once one accepts that there are exceptions, then the only rule that makes sense and is consistent with, for instance, what I showed you that the Advocate General said in Eturas, is that you look at the context and you decide on the context whether there was or wasn't consensus. Final point to add in relation to that is that insofar as there is assistance from the courts in relation to public distancing, it is inconsistent with what Mr. McLean says. So there's the case of total marketing, which Mr. McLean relied upon. And in my submission, I'm going to come to it, that case is inconsistent with the submission that you always need public distancing in order to get yourself out of jail. So if we could turn, please, firstly to the Advocate General's opinion. It's to be found in the authorities bundle, tab 50, beginning on page 2951.
Tab 50.
Tab 50, 2951. I haven't give myself a volume reference there. Is the court going to use electronic authorities?
Fine.
I'm grateful, good.
I think there's a mixture there, unfortunately for you.
What's the
What's the
candle waxes cartel? The
Sorry?
candle waxes cartel.
Yes, exactly. And the case concerned an undertaking which had been part of the cartel, but for a period stopped attending the meetings. And the question arose whether, as the Commission and the General Court have found, it should be deemed to still be part of the cartel unless it's publicly distanced. And if we pick up the Advocate General's opinion, please, starting at paragraph 44. He says, for the purposes of examining the complaints raised in this appeal, it's necessary to bear in mind certain key principles governing the adducing of evidence and the burden of proof of an anti-competitive behaviour. It should first of all be recalled that it's for the Commission to prove not only participation in the cartel, but also the duration of that participation. In accordance with the presumption of innocence, the benefit of any doubt that exists regarding the duration, continuity, must be given to the undertaking. Then, if I could ask, if we then go to paragraph 51, it then begins to deal with public distancing. How is the requirement that an undertaking must publicly distance itself to be understood in this context? And then he says at 54, faced with that question, the court confirmed the approach advocated by the Commission and endorsed by the General Court. In that case, it held that it was sufficient for the Commission to show that the undertaking concerned had participated in meetings at which anti-competitive agreements were concluded without manifestly opposing them, to prove to the requisite standard that the undertaking in question had participated in the cartel. So what I emphasise there is anti-competitive agreements were concluded. That's the point I was making to my lady earlier on. And it's for that undertaking to put forward evidence to establish its participation in those meetings was without any anti-competitive intention, by demonstrating that it had indicated to its competitors that it was participating in those meetings in a spirit that was different from theirs. So just pausing there, the necessity of that is because there is a complete infringement at that point. And he then goes on, it's in this way that the public distancing requirement, which is based on the essential premise that the undertaking has participated in a meeting or that it was engaged in anti-competitive contacts, is to be understood. The court is therefore careful to make clear that the reason underlying that principle of law is that having participated in the meeting without publicly distancing itself from what was discussed, the undertaking has given the other participants reason to believe that it subscribed to what was decided there and would comply with it. And then it goes on at paragraph 56, a couple of lines down. To my mind, the reference to no public distancing does not make up for the lack of evidence of participation, albeit passive, in an anti-competitive meeting. And then over the page, at 58, in the light of the foregoing, the public distancing requirement makes sense only if the undertaking has actually participated in collusive meetings, or at the very least, if there is evidence of concerted practices over a period. It should thus come into play only in circumstances where it's reasonable to presume, in the light of evidence specifically gathered during the investigation, that the defendant undertaking has continued to participate in a cartel. The fact that an undertaking does not publicly distance itself from a cartel is not in itself such as to constitute evidence of its participation in it. So that's the analysis of the Advocate General. And in my submission, entirely underpinning my point, the way that the judge came about this, which was to look at public distancing where he did, after consultation, before cause and effect, was exactly the right place to look at it. And one sees that the Court of Justice followed that reasoning, not expressly, but in terms of referring back to the Advocate General, but it did follow the same reasoning in the judgment at paragraphs 20 to 24. So that's page 2969 of the bundle. And if I could ask, please, the court to read 20 through to 24.
Yeah.
So I'm going to come back to this, these few paragraphs in my submissions under ground 2.2. So I just want to draw attention to one thing that's relevant to that before completing this submission. The court will have seen that from paragraphs 20 to 24, we are dealing with participation in the agreement or the consultation. We are not dealing with anything to do with the third element of a concerted practice. That's the relationship of cause and effect. That's a side. I'll say that in parentheses now because it's going to be important later. The essential point for my purposes now is that a lack of public distancing does not bring an infringement into being where there wasn't one already.
Well, that's the real point, isn't it? That's
yeah. And it's important to note that where...
This is talking about a situation where there is already an infringement in place.
Exactly.
Because there have been anti-competitive meetings going on over a period of time.
Exactly.
And this context is somebody who's participated in those anti-competitive meetings.
Yes.
Therefore colluded in the past and now wants to get out of it.
Yeah.
And what they're saying is, you can't get out of it unless you publicly distance yourself, which it makes perfect sense.
Well, no, they're actually saying that you don't have to go that.
Well, there are other ways.
Yes, there are other ways. There are other ways.
But that's the obvious way.
But yes, that's the obvious way. But what we're actually saying is there are also other ways.
But it's not what it doesn't seem to be saying, because I think, from recollection, although Mr. McLean showed us JJB Sports, I think, in the CAT, where they rely on Aalborg Portland Cement. But Aalborg, which is the case that the Attorney General talks about, the Advocate General talks about, was a case, was it not, where there had been a whole series of anti-competitive meetings.
Yes.
And the issue was whether participation in a meeting and saying nothing was sufficient to amount to non-involvement, and the answer was no, it isn't.
Correct.
We'll do more.
Correct. And the key point, whether we're talking about agreements or we're talking about concerted practices, is the crystallisation of the consultation or the agreement. So where these cases refer, and indeed one finds it in Eturas, they refer slightly loosely to participation in an anti-competitive meeting. But it's quite clear, if you trace that through in the case law, as I've sought to do, and indeed, as the Chancellor, you helpfully also noted one of the other cases, what that's referring to is where something crystallised has happened, which is the bad thing, and you're looking to distance yourself from that. It's not a requirement that you must publicly distance in order to even avoid getting trapped.
Avoid being in a concerted practice.
In the first place, exactly.
Okay.
And indeed, I note in passing here, this is a slight jury point, but I'm going to make it.
Surely not, Mr. Pitt.
If Phones for You were right, then what we would have is a situation where Mr. Rowe, leading competition lawyer at Slaughter and May, gave grossly negligent advice, because what he saw is he saw the facts and he didn't say, oh my God, what you need to do is get in there and write the publicly distancing letter. He said, actually, I think we can leave it.
Go to the CMA this afternoon.
It's maintained. Now, I mean, my submission is he obviously wasn't giving grossly negligent advice at all. His position was entirely consistent.
Well, he was clearly very worried by the situation, which is a different point.
Very different, yeah. But the advice was not, unless you publicly distance, you are stuck.
Right.
So that is it on ground one.
Would it be sensible to take a break now?
Whenever it's convenient for the court.
Well, should we take a break now? Shall we say, well, on that clock, if we can come back, is 5 or 6 minutes going to be enough if we're going to go until 5 o'clock? You're the advocates. So
yes.
We just have to listen. I'll say 1/4 then.
Thank you. Yeah.
Sorry about that reference. It's volume 12. I checked this. No other.
Yeah.
Same for each of us.
Who's been asking for?
You wait till Friday morning. We haven't done one.
There's nothing nice.
I believe you are. Thank you.
Scottish standards.
Paul, Brian, look at able.
My lords, my lady. Before I begin round two, my learned junior has pointed out to me that my memory for numbers is not as good as I thought it was. I gave a reference to paragraphs 197 to 203 of the judgment for where the judge makes findings about the general desire to reduce reliance on directs. It's in fact 97 to 103, so I added on 100. So turning then to the Anic presumption. The grounds grouped under ground 2 concern the third element in establishing an unlawful consecutive practice, namely a relationship of cause and effect between consultation on the one hand that we've just been discussing and subsequent conduct on the other, and the role that's played in that regard by one of the presumptions in Anic.
Yeah.
If we could please go to Anic itself. It was telling that Mr McLean didn't actually take you to the case that sets out the presumption on which he bases 5 of his grounds. If we could go, please, to Authorities Bundle Volume 9, tab 36, and it's at page 2090.
Yeah.
So this was a case where Anic, along with several other companies, participated in a polypropylene cartel, and the European Commission found that they engaged in systems of setting target prices, limiting production, etc. And notably, one sees from paragraph 8 of the judgment that the cartel took place at a number of meetings, and that will become relevant as we get to ground 2.2. Now, there are 2 key issues which Anic is concerned with, which were relevant to our trial. The first issue is the one we've just been grappling with, which is the presumption that if you participate in a meeting where an anti-competitive initiative has been decided upon, planned and monitored, then it's up to you to show that you didn't participate in it. The second one is the one that we care about under ground 2. But it's important to know that both are there because what Phones for You has done in this case is confuse the 2. So if we start off then very briefly, we look at paragraph 90.
Slightly confusingly, it's the second that's called the Anic presumption.
Indeed. So if we go to page 2153 of the bundle, please. And if I could just ask the court, please, to look at paragraphs 96, 97 and 99, and they'll see very familiar themes there, given the points that we were discussing just before the short adjournment.
We're 96.
96, 97, through to 99, although 98 is less important.
Yeah.
So that's the first presumption that we've basically been grappling with already. and then the second presumption, which is the one that's relevant to ground 2, is, you pick it up at paragraph 102 in the judgment, so that is on page 2154. And by its fourth plea, Anic criticises the Court of First Instance for having wrongly rejected its complaint that the infringement had not been legally characterised as either an agreement or a concerted practice within the meaning of Article 85 of the treaty, now 81. And then at 103, what Anic says in summary is this. They say, whereas in a case of an anti-competitive agreement, liability crystallises when the agreement is formed and without the need for any implementation, in the case of a concerted practice, there needs to be both the anti-competitive intent and some, as they describe it, physical element, i.e. conduct on the market, to compensate, as they describe it again, for the evanescent nature of the mental element. So that's the idea behind the three, or that's their presentation of the idea behind the 3-element test for consultations, as opposed to the 1-element test for agreements. And then one sees the court dealing with that submission at paragraph 115 and following. Thirdly, it must be borne in mind that concerted practice within the meaning of Article 85, 1 of the treaty, refers to a form of coordination between undertakings which, without having been taken to a stage where an agreement properly so called has been concluded, knowingly substitutes for the risks of competition practical cooperation between them. Again, just pausing on those words, practical cooperation between them. That, in my submission, yet again informs the idea of there being consensus, and that is what was missing, going back to what I was saying on ground 1, from what Mr Swanty gave. He gave no practical cooperation. And then, if I could ask the court, please, to, after 116 to 117, which explain the justification for the principle in 115, we then get to 118, and that sets out the 3 elements for a concerted practice, which we're hopefully now familiar with. And then the court says at 119, the Court of First Instance therefore committed an error of law in relation to the interpretation of the concept of concerted practice in holding that the undertaking's collusive practices had necessarily had an effect on the conduct of the undertakings which participated in them. So they overlooked the requirement for elements 2 and 3, but then the court goes on at 121 to develop the presumption, which then effectively gets the court off the hook again. So if I could ask, please, the court to read 121, which is the articulation of the Anic presumption that matters for ground 2.
Yeah.
And what I ask the court to note here is that it's expressed in entirely general terms, notwithstanding that this was a case about meetings. The court does not say, of course, the only evidence that we would ever accept would be public distancing. And that is in contrast to the way that the court was dealing with the first part of consultation at 96. They don't use the word public distancing, but they do say it's in that case the undertaking to demonstrate that they had no part in it, which is now a term of art, public distancing. So expressed in entirely general terms, that's the presumption. If we could then go back to the judgment and see how this was addressed by the judge. We find we're back in, obviously in the core volume 2A, and if I could pick it up, please, initially at 218 paragraph 218, page 324, very, very briefly. So that's when the judge deals with what I call the first Anic presumption issue, and he ultimately rejects EE's case that we publicly distance. And then that finishes at paragraph 230, and then at 231 he moves on to a new issue, namely the relationship of cause and effect between the consultation and conduct on the market. And what one sees, I think we've been to these already, but what one sees at paragraph 231 is that the judge says, well, I'm going to apply the presumption to EE, assuming hypothetically and contrary to his initial finding that there had been consultation. And then he finds that it's clearly been rebutted on the facts, because we went and did the opposite of what Dunn might have been hoping for. And he concludes by saying, indeed, I don't think that Phones for You really suggested that the exchange between Mr. Dunn and Mr. Swansea influenced EE's conduct on the market. And he was right to say that, because that wasn't their case at that point. And then at 232, the judge does two things. So the first thing that he does in the first two sentences is he draws the conclusions from 231 in relation to whether there was a completed infringement based on information flowing from O2 to EE. So he says, I therefore conclude that EE was not a party to a concerted practice in violation of competition law by reason of the landmark lunch and its aftermath. Since a concerted practice must, by definition, involve more than one party, that effectively means that O2 also was not a party to a concerted practice by reason of these matters. So that's the analysis based on what did O2 say, did it lead to an influence on EE's ultimate behaviour? And then he goes on to say, in any event, the presumption of reliance on commercially confidential information as affecting conduct on the market obviously does not apply to the party disclosing the information. And as I found that Mr. Swansea made no disclosure to Mr. Dunn of EE's position, nor did he offer to give any support from EE for O2's strategy, I do not see any scope for the Anic presumption to apply as regards O2. So he didn't apply Anic there, even in the alternative, because his view is that, well, that just makes absolutely no sense, because my findings are there simply wasn't anything for it to bite on. So that's his conclusion there. So that's the background to this. I've taken you to the Anic presumption itself. I've taken you to how it was applied by the judge in the judgment. I then go to the grounds of appeal that are raised by Phones for You. And I say that there is a somewhat shifting case from Phones for You, which is apt to cause confusion, but ultimately there are no arguable points of law in here. So ground 2.1 concerns the scope of the presumption. And I say it relies principally on mischaracterising the judgment. So as I understand the basic proposition of law, it's this. Phones for You here to say that where one party A discloses information, it's also pursuant to the Anic presumption to be presumed to take into account such information as it receives back from B in response, including where information can be inferred from B's passivity or silence. That's, for instance, their skeleton at paragraph 49. Now, my answer to that is as follows. Don't have any objection to that proposition of law if it really is the case that B's passivity amounts to a communication of information which substantially reduces or removes the degree of uncertainty on the market, the test that Mr. Hoskins was explaining to the court, then we do indeed have the basis for the application of the Anic presumption in relation to what A then goes on to do, because there's an information flow from B back to A. And the judge didn't find otherwise. The problem is, those aren't our facts. What the judge found on the facts which I showed...
Well, it's those last two sentences, isn't it, of 232?
Yes.
Because what he's saying there is it makes no sense if you don't apply the presumption to the discloser, here, O2, in circumstances where nothing's come back from the other side. Non constat if something had come back from Mr. Swansea.
Right.
Then E would be disclosing to O2 and the presumption would apply to O2. But it doesn't on the judge's finding.
Exactly. So that's the core point. There are just a few more points on that, because another way that Phones for You put it is they say, I think Mr. McLean put it in these terms exactly when he's making his point on Monday. Passive receipt of an anti-competitive disclosure conveys information back to the disclosed undertaking. And the point is, it depends. It may, or it may not. But that's a factual issue. It's not. There's no principle of law that it does so. And in my submission, that's the answer to ground 2.1. Ground 2.2 concerns the means of rebutting the Anic presumption. So I'm willing to accept here that this is a point of law. The problem with it is it's a bad point of law as far as Phones for You are concerned. So what they say here is that because the alleged collusion took place at a meeting, as opposed to, say, via WhatsApp, the only form of evidence that would be permissible to rebut the presumption of a relationship of cause and effect between consultation and subsequent conduct on the market would be public distancing. Now, before getting into the detail, it's worth considering what it would mean for Phones for You to be right. The judge found that the presumption was rebutted because EE did the exact opposite of what Mr Dunn might have been hoping for. Now, Phones for You does not contest those findings of fact. What it says is that the judge was disabled from finding that the presumption was rebutted, even though they don't contest the factual basis for the rebuttal. They just say it was the right type, it was the wrong type of evidence. It was the wrong type of snow, the wrong type of leaves on the lawn. Now, they say that the judge was forced to find that EE's conduct was affected by the landmark lunch as a result of this presumption, even though on the uncontested facts, it wasn't. Now, in my submission, that is an Alice in Wonderland view of the law in this area. It turns the role of a presumption on its head. Because what a presumption is supposed to do is to alleviate one party, namely either the claimant or the fact finder, of proving something as true, which is inherently likely. It's put, we don't need to turn it up, but it's put by Advocate General Ruiz Haribo in the Albo Portland case as being based on the logic of reason and also on common understanding and experience. You'll reference that paragraph 128 of his opinion on page 2281 of the bundle. And such positions are considered consistent with the presumption of innocence, provided that they remain rebuttable. Again, just for your note, that's the Advocate General in Naturas, paragraph 55 of his opinion, page 2997 of the bundle. But they obviously aren't intended to hamstring a court into making nonsensical findings that don't correspond to their careful analysis of the true facts. Indeed, it leads, if Phones for You is right, into quite unsustainable distinctions between different factual situations. Let's suppose that Executive A, who works for Undertaking A, discloses sensitive information to B. And then Executive B, Undertaking B, has a heart attack 1 minute later, dies, never engages in any public distancing, but obviously doesn't act on that information either. It obviously never went anywhere.
Mm.
Now, in that situation, we say it should be permissible to reduce evidence that B dropped down dead, and that nothing ultimately came of the consultation in terms of cause and effect. But what Phones for You say is, well, it depends. Can you tell me, was it at a meeting? Because if it was at a meeting, well, no, you can't do that. Was it by WhatsApp? Oh, yeah, no, by WhatsApp, that's fine. It works. They accept.
Well, unless you use WhatsApp, unless you've got it on WhatsApp with a video.
Well, quite. Exactly. Exactly. Is it WhatsApp with a video? Is it, what about Teams? What about a Teams meeting?
Yeah.
What about the chat bar, that's the side of a Teams meeting? It's a totally nonsensical distinction. It has no sensible basis for it at all. And indeed, it doesn't accord at all either with public policy, because in the context of the first Anic presumption, it obviously makes sense to give one example, to fix C with liability if it sits there quietly in meetings when A and B get on with their cartel. So public distancing is sensible and makes sense in that context, but it doesn't make sense at all in the context of an issue about cause and effect. Suppose on our facts, suppose what happened in our case is that we wrote Mr Dunn a letter which said, you approached Mr Swanty, you did a very bad thing, and we thoroughly repudiate what you've done, and we are publicly distancing ourselves from it. And then suppose what happened is that EE went and did exactly what Mr Dunn had been hoping for, and pulled out of Phones for You at exactly the same time as O2 did. On their analysis, they say that we have a complete defence, and the reason we have a defence is because there's no relationship of cause and effect between the consultation and what happened. And that's totally illogical. It doesn't make any sense. But the reason why they say it is because we've done the thing that they say that we are entitled to do, which is to publicly distance. So,
well, in that example of public distancing, it would just be a subterfuge, wouldn't it?
it would.
You'd have to look at the totality, and you say you have to look at the totality of the evidence, which demonstrates the link between cause and effect, despite the protests to the contrary.
Yes. I mean, it's just aiming at a different issue. Questions about a causal relationship, in my submission, have got probably relatively little to do with the public distancing issue. I'm not saying they're necessarily totally devoid from it, but they're not the same point. I think indeed this was a point that my lady was making on day one, when you said you were struggling to understand some aspect of the submission that was being made. So that's the context for this. I say this point simply doesn't make any sense. And when one looks at the case law, there is no such principle. And Phones for You's case rests on a misunderstanding of a passage in iteris. And we're going to go through that and I'm going to explain it. So if we could then go, please, to that authority. It's in volume 12 of the bundle at tab 51. And we can pick it up very briefly at paragraph 26, which is, I think it's on 3002 of the authorities bundle. So 26 is the question that was being referred, and hopefully we're now relatively familiar with that. And then at 28, we see the statement that the courts also held that passive modes of participation in infringement, such as presence of an undertaking in meetings at which anti-competitive agreements were concluded, without the undertaking clearly opposing them, are indicative of collusion, capable of rendering the undertaking liable under Article 101, since a party which tacitly approves the unlawful initiative without publicly distancing itself from its content, reporting it to the administrative authorities, encourages its continuation, in effect. So, a point that we're now hopefully well familiar with. So we're dealing here with the first Anic presumption, not the second one, about the relationship of cause and effect. And then we go on 29 in the first place, and that court will see, and indeed I think my lady put it to Mr McLean, that's still obviously on the same subject matter. 32, we're still in the same subject matter. 33 is worth pausing on, because here the court momentarily switches to the second presumption about the relationship, the causal connection between consultation and conduct. But the reason it does it is to go back to, making a point still in the context of the first issue, because it then goes back at 34 to say, however, in contrast to that presumption, the answer to the question about the dispatch of a message, etc. So we're now back again in the territory of the first issue. And then at 42, we're still in the second, we're then having the second place, and we're still at that point, and I think Mr. McLean accepted this, within the realms of the first Anic presumption. And still, that's the case at 44 and 45. And then the debate is, well, what happens at paragraph 46? Is this the point where we switch to the third presumption? Or am I right that we switch 3 paragraphs on in paragraph 49? And there are 3 reasons that I give for why my interpretation must be right. So the first is that in the context of where we have been going with the first place, the second place, and the third place, this is all still part of that discussion about participation in consultation. And we note in paragraph 46, there is no reference back to, for example, 33, which is when the court introduced the contrasting presumption about the causal link. So that's the first contextual point.
You've only got to read the whole paragraph to see that it's referring to the first presumption.
Indeed.
Must be pointed out, travel agents may rebut the presumption that it participated in a coercive practice.
Yes.
And then towards the bottom, rebutting the presumption a company has participated in an infringement. So it's looking at how you rebut that presumption.
Exactly, my lord. And there are further bits of proof. The second piece of proof is that the reference, the citation that's given by the court here is to total marketing. And I showed you these very paragraphs of total marketing, and they're all about the first presumption. They're nothing to do with the second presumption. So,
yeah.
And then the third point is the contrast we see between this paragraph and 49. So if we then go on to 49, which is dealing with the third presumption, sorry, the second presumption about the third element. If I could ask the court, please, to read paragraph 49. And what one sees here, in contrast to paragraph 46, is that the reference back in 40, well, for a start, it clearly introduces the second presumption. because it talks about the rebutting, it talks about the presumption of a causal connection and how one might rebut it. So we're quite plainly in the territory at this point of the third presumption.
Yes, I mean, the first couple of lines of 49 refer to presumption of participation. So it's not, this isn't entirely straightforward, is it?
I would certainly not disagree with the point that the court might have put itself more clearly in 46 and 49.
I mean, it still seems to be dealing with the first presumption.
Well,
Possibility of rebutting presumption of participation in concerted practice by means other than public distancing. So that bit seems to still be about the first presumption. But then it must be held in circumstances such as those at issue, the presumption of a causal connection between the consultation and the market conduct, etc. That's clearly the second presumption.
yes.
And you say, well, that is clearly the second presumption, and they also indicate that you could rebut it by other means than public distancing.
Yes, and in distinction to paragraph 46, what we note here is that they refer back at this stage to paragraph 33 of their judgment, and that was when they introduced the second presumption. That was when they introduced the causality issue. They don't refer back to 46, which is what would make sense on Mr. McLean's approach to this. And what I understand that Mr. McLean says is, well, look at those words, circumstances such as those at issue in the main proceedings. We know that the circumstances in issue didn't involve a meeting. Therefore, what this is saying is that there is a requirement that you can only employ this in situation where you can only rebut generally by any evidence in a situation where you're outside a meeting. And we say that's reading far too much into those words. The reason why those words are there in this paragraph 49, the circumstances such as those at issue in the main proceedings, is the conclusion at 49 that it could be rebutted by evidence of systematic application of a discount exceeding the cap in question. That's a case-specific issue. So obviously they need to set that up. It's not doing what Mr. McLean says it's doing. So their final shot on this is Sainsbury's and Visa. And I don't think I need to say too much about that. I accept that the Supreme Court were right about almost everything that they said, apart from the fact that in paragraph 113 of the judgment, we don't need to go to it, because I think you should well have my submission. They refer to the causal presumption, and then there's a reference to paragraphs 46 to 49 of Eturas.
Yeah.
So it looks as if the Supreme Court are thinking, well, that's what is in discussion there. It's just the third element. It's the causal connection. Look at 46 to 49. That is a slip.
Was it? I don't remember this point coming up in the Court of Appeal at all.
I don't think it did come up in the Court of Appeal.
I just wonder where it came from.
Well, my memory is...
Were you in the case now?
I was in the case.
Yes, I thought you were, yeah.
My
recollection is the Eturas, I don't remember the Eturas point ever coming up in the Court of Appeal. Did it actually come up in argument in the Supreme Court?
It did. My recollection is it was a point being made in particular by Visa.
I was acting for MasterCard.
Well, that's why I'm saying Visa, because I believe it was.
It's almost Rose's fault in that case.
Sorry?
It's almost Rose's fault in that case.
Well, I would never say that. And certainly not to her.
No, I just wondered whether it was sort of whether it's really just part of the sort of obiter comment.
It's entirely obiter because the point in Sainsbury's, as Mr. McLean I think was showing you yesterday, was about whether you can have presumptions in EU law that feed through into an analysis of how the domestic court approaches something. And the answer to them was there are certain issues. For example, there can be issues where the nature of the evidence is a question of EU law.
Yeah.
And then the question is, you still apply your domestic standard of proof
Yeah.
to the EU law question of what, as a matter of EU law, you are entitled to prove. In that context, it was all about, in fact, what you needed under Article 1013. So it was all about, efficiency defences. It had absolutely nothing to do whatsoever with the subject matter that we're considering here. And so it's unsurprising that in a somewhat difficult to parse passage of Eturas, which I say, on its face is not totally clear, the Supreme Court made the tiny slip that it did in referring to paragraph 46 when really it should have just said 49 on that issue. And then you heard from Mr. McLean yesterday about what they say about Solvay. Because we say, well, Solvay is a case predating Eturas. And it's entirely contrary to Mr. McLean's submission, because what happened in Solvay is that, as the court was pointing out to Mr. McLean, is in Solvay it's a case involving a meeting, and yet what the court does is consider on the merits whether the Anic presumption has been rebutted by the type of evidence that Solvay is relying upon. It's about pricing studies, etc. Now, that would have been a legally impermissible route if Mr. McLean's approach was right, because that would have all been totally irrelevant. It's a case about meetings, so there was a very simple way through. In fact, the only legally permissible way through, which was for the court to say, I'm sorry, but your evidence is not the right type of evidence. It's not about public distancing, therefore it's inadmissible. And Mr. McLean says, oh, well, courts often consider other things when they don't need to. In my submission, that is the last thing that the Court of Justice ever does. In the Court of Justice, the issues about admissibility and the effectiveness of appeals are always paramount. And the idea that the court went off on a frolic of deciding factual points and considering factual points that it didn't need to because they were legally irrelevant is not a realistic submission. So he's defeated by Solvay. He is also defeated by T-Mobile, which is yet another case which involved meetings, and yet the point is put in terms of how one rebuts the Anic presumption in entirely general terms. It doesn't say there's a special rule for meetings, it's got to be public distancing. And he's also defeated by Scania, which postdates Eturas. And just to put the final nail in the coffin on this one, if we could please go to Scania. That's in volume 14 of the authorities, tab 59, and I'm going to page 3449. And if I could ask, please, the court to read 99 and 100. So the submission that I make in relation to these is here the court conveniently sets out the two presumptions, right juxtaposed, right next to each other. The first one involves the public distancing point. The second one, the second Anic presumption that we care about under ground 2, doesn't mention public distancing. They're put in their classic formulations, post-Eturas, in the way that the court always puts them. So just to close this off finally, I'd say it would be a very, given what I said about the Solvay case and how Solvay, the approach that the court adopted in Solvay, that was an anti-competitive meeting case. It would be very odd if Eturas, which wasn't a case involving anti-competitive meetings, somehow overruled Solvay, which was. You'd expect to see that spelt out very clearly, and it's simple. Yeah. So that is ground 2-2. Those were the two most chunky ones of ground 2. So I'm going to move on to ground 2-3, which concerns the evidential threshold for rebutting the Anic presumption. Now, we say that this is a return to dressing up what is ultimately an impermissible factual quarrel as an error of law. The court has already seen judgment paragraph 231, which contains the key findings on the rebuttal. And we may as well go back to it. That's on page 328 of the bundle, paragraph 231 of the judgment. So that's what the court said about whether we'd rebutted the presumption. We'd obviously rebutted it. And what Phones for You now say is, aha, that didn't meet the test in Solvay, because the test in Solvay, they say, is a very high test. And we haven't got over the barrier of that high test, or rather the judge didn't get over the barrier of that high test. And I have 5 points to make in response to that claim. The first of them is this. By the end of trial, as the judge records in the final sentence of paragraph 231, Phones for You never advanced a theory that EE's exit decision in 2014 was directly influenced by the vague approach of Mr Dunn in 2012. And they never argued that the Anic presumption should apply in relation to that alleged causative link. Now, Mr McLean showed you extracts from his Phones for You's submissions, but in my separate submission, they don't show that case being made to the court. The only concrete case that Phones for You did advance was the so-called indirect theory that O2 had been influenced in its exit decision by Mr Swanty's silent and impassive reaction, so they say, and that thereafter EE was in turn influenced by O2's exit. So they did go to that case, but that is not a basis for the application of the second Anic presumption to EE. That depends on applying it to O2. And Mr Hoskins is going to deal with that, but we know why the judge didn't apply it to O2. It's because there was nothing for it to bite on in relation to O2. So we say that point goes nowhere because this was never their case at trial. That's the first point. Secondly, it was never consistent with that. It was never put to Mr Swanty. And Mr McLean acknowledges that it was never put to Mr Swanty, but he says, well, I didn't need to put this case about what EE's reasons were and whether it was influenced in 2014 by what happened in 2012 to Mr Swanty, because he'd already denied that he took anything from the approach. That's what Mr McLean said to you, I think it's yesterday. And we say that is not good enough, because in his answers, Mr McLean was at pains to argue that the idea that the 2012 approach assumes some far deeper, more powerful meaning later on in 2014 was distinct from what Mr Swanty took at the time. That was how he sought to avoid the findings that are plainly against him that were put to him by my lady about, I think it was paragraph 208. he said, well, that's all different because that's what Mr Swanty thought at the time. My theory is distinct from that. Well, if it's a distinct theory, claiming to put it to Mr Swanty, he didn't put it to Mr Swanty, so we can't rely on it now. That's the second problem. Third problem is one, in fact, I've managed to sweep up into my interest, the first one, which is, as regards whether Anic applied to O2's decision making, we say there's no scope for it to apply on the facts. So you address that. Apologies for giving it to you twice. And then the fourth is that in any event, there was simply no error by the judge in his approach at paragraph 231. You have my submissions on why, in fact, this is just for completeness in any event, because this wasn't really a point that was being advanced by Phones for You. And all that Solvay requires, as Mr. McLean showed you when he took the court to it, is that any link between consultation and conduct on the market be discounted. That's the point he's emphasising. He said, yeah, but you've got to hit any link. So he says that's a high bar. And my response to that is it's no different from any of the other law in this area. It's not. It doesn't trespass into the issue of the standard of proof, because we all know and agree that that's on the balance of probabilities. That's Sainsbury's. It's simply saying that what you have to rebut depends on the nature of what the consultation was. And if I could go to Solvay to make that good. So that's in the authorities bundle, which is volume 11, tab 46, page 2714. So we see that paragraph 9 of the judgment, which is actually over the page at 2715, the infringement found consisted mainly of competitors exchanging commercially important and confidential market and company information, limiting and controlling production, as well as potential and actual production capacities, allocating market shares, and customers, and fixing and monitoring adherence to target prices. So it was a very wide-ranging cartel that covered all sorts of aspects of their commercial behaviour. And so one statement to the obvious that if what the defendant then came along with to seek to rebut the Anic presumption was only limited to one aspect of that, namely pricing, they were going to have quite a job in demonstrating that that they had rebutted the entirety of the Anic presumption as it applied to everything that was part of the cartel. So if we go on to paragraph 43 of the judgment, we see the paragraph that states the point of principle that Mr. McLean relies upon. And we have no problem with the terms in which it's put. And what the court then goes on to do is to reject the analysis, which is effectively about pricing data, as being sufficient to rebut the presumption. But we say, well, obviously, that would be insufficient in a very wide-ranging cartel, and there's nothing wrong with the requirement that you have to rebut every aspect of the collusion. But in our case, there was only one thing that was on the table, which is this issue about withdrawing from, pulling back volumes from Phones for You.
Yeah.
And even if I'm wrong on everything else that I've said this afternoon, I say the one thing is very crystal clear. We did the opposite. We did the opposite. And so that was the only game in town. And that was properly addressed by the judge, because there weren't other aspects to consider in the same ways that there were in Solvay. And the fifth, final point on this ground is that we, with respect, say that the judge was right to describe this theory as frankly preposterous. Because what it depends on is accepting the submission now made only on appeal, that when it decided to leave Phones for You in 2014, having observed what had happened in the market, which is that Phones for You, that O2 had already left Phones for You, what EE put weight on was a vague and conditional hint some 2 years earlier that he might have been interested in some kind of coordinated action in the indirect sphere. And we say that was manifestly, well, firstly, it wasn't, obviously, you have all the submissions about why it wasn't sufficiently detailed in any event. But plainly, it was overtaken by events. And so this theory is simply not a credible one that this court needs to worry about. So that is what I have to say on ground 2.3. That then takes me to ground 2.4, which I can hopefully also deal with briefly. So ground 2.4 concerns the relevance of the Anic presumption to the domestic law causation analysis that the judge relied on. And we say it relies on the proposition of law which is hopeless. So what Phones for You say is that the Anic presumption prevented the judge from assessing the impact of the landmark lunch on the facts as a matter of ordinary English law on causation, but rather bound him inevitably to find that Mr Swanty's passive response actually caused O2's decision to exit Phones for You, whether it did so or not. This, in large part, relates back to a point that I was making earlier on a different ground. We say that is wrong in law and contrary to all common sense. And I have 3 points, short points to make.
I'm really sorry to interrupt, but I thought I was going to take it.
Oh, I'm very sorry.
That's fine. It says no 2 point.
Right, I'm very happy in that case to stop.
Well, is Mr Hoskins saying you're trespassing on his
Mr Hoskins, yes, I think there's been a failure of coordination and insufficient consensus between me and Mr Hoskins as to how we were going to organise who dealt with 2.4. I'm very happy for Mr Hoskins to take over.
All right, thank you very much, Mr Pickford. Yes, Mr Hoskins.
Mr Pickford can sweep up the mess after me if I do that, no doubt. This ground only arises on the assumption that a concerted practice had arisen between O2 and E as a result of the landmark lunch.
Yeah.
And there's a specific question in the trial, which is, even if an infringement had arisen as a result of the landmark lunch, did that concerted practice have a causative influence, in fact, on O2's decision to leave Phones for You? So it's a domestic damages causation issue, assuming an infringement had been found. And obviously, even if Phones for You could establish that the events at the landmark lunch gave rise to concerted practice, it couldn't recover any damages if the infringement didn't cause it any loss. That's what we're looking at. Now, you'll have seen that the judgment contains a detailed analysis of how O2 in fact reached the decision to withdraw from Phones for You. It's paragraphs 104 to 146 and 246 to 272. And that was done for entirely independent commercial reasons, and that's set out in detail in the judgment. But when the judge comes to consider this particular point, i.e. domestic factual causation, that's dealt with at paragraphs 233 to 235 of the judgment, so core bundle, tab 18, page 329. And you've seen these you've been taken to these in some different contexts, but I'll ask you to refresh your memory on these, because these paragraphs are actually dealing specifically with this factual causation point and nothing to do with the finding of infringement. So if I could ask you to reread 233 and 234, please. Indeed, sorry, down to 235. So you see, what the judge is saying is, regardless of any presumptions that might apply in order to establish an infringement, as a matter of fact, I find that Mr Dunn could not possibly have regarded E as indicating support. So that's a purely factual finding, and he leaves aside all presumptions. Now what Phones for You say is, as a matter of law, he should have applied the Anic presumption to the domestic causation exercise. And we say that, as Mr Victor was about to tell you, that is wrong as a matter of law. Clearly, the Anic presumption does not apply to the domestic law of causation. First point is, it's clear from Anic itself that the presumption applies regardless of any concrete effects on the market concerned. The Anic presumption has nothing to do with concrete effects. If you go to Anic, that's Authorities Bundle 9, tab 36.
Yeah.
Page 2158.
Yep.
And you've seen paragraphs 119 to 126. Again, perhaps it's sensible just for you to refresh your memory as to what is said there. And the point that's been made by the court is that, as a matter of substantive law, you don't need to show an effect in order for there to be a concerted practice. And the Anic presumption is just that. It is a presumption which is relevant to the infringement, but it's not a finding that there have in fact been any effects. And the court made it clear that the Anic presumption does not include an assumption that conduct in fact produced a concrete effect on the market. You see that in paragraph 119. The court first instance committed an error of law in relation to the interpretation of the concept of concerted practice, in holding that the undertaking's exclusive practices had necessarily had an effect on the conduct of the undertaking which participated in them. 122, for another, a concerted practice falls under Article 85.1 of the treaty, even in the absence of anti-competitive effects on the market. 123, concerted practices are prohibited regardless of their effect when they have an anti-competitive object. And 124, although the concept of a concerted practice presupposes conduct of the participating undertakings on the market, it does not necessarily imply that the conduct should produce the concrete effect of restricting, preventing, or distorting competition. So even applying the Anic presumption in the context of infringement, it's not to establish that there was in fact an effect, because that's not necessary as a matter of law. And secondly, the question of whether an infringement has caused loss to a particular claimant is a matter for national law. I'll take you to two authorities to make that good. The first of the judgments of the Court of Justice, in a case called Manfredi. That's Authorities Bundle 10, tab 40.
I'm not sure we need much help on that.
It's well-trodden path, exactly.
Yeah.
I'm not going to dwell long on it.
I mean, Manfredi is pretty well known.
Absolutely.
By all means, show us a relevant passage.
That's it. Page 2419.
Okay.
And it's paragraph 64.
Yeah.
you say, very well trodden path. And then just to show you a domestic authority, this time the Supreme Court, in Deutsche Bahn and Morgan Advanced Materials, that's Authorities Bundle 4, tab 14.
Yeah.
So you'll see this is a judgment of the Supreme Court in 2014, and it's paragraph 11 on page 844. And it's literally the first sentence. The existence of any loss and of a direct causal link between any loss and the agreement or practice in question are matters for the national court. Yeah. So we've debated about the application of presumptions to find an infringement.
Yeah.
Regardless, and this is assuming that infringement has been found, when you come to the position of saying, has that infringement caused any loss, that's purely a matter for national law, and the Anic presumption has absolutely nothing to do with it. And the relevant question, if one assumes that the Landmark Hotel did give rise to an infringement, is did any concerted practice have a causative influence, in fact, on O2's decision to leave phones for you? And the judge found, as a matter of fact, that it did not. There is no error of law in the judge's approach, quite the contrary, and those were findings of fact that the judge was clearly entitled to make. And therefore, that part of the appeal must fail. And that's all I have to say on that.
Thank you very much.
So, in the escalation arguments, there is a ground 2.5. It didn't seem to be disputed by Mr McLean. It's addressed in our escalation argument. I'm not proposing to say anything.
No, okay.
It's effectively a regurgitation of other points of grounds 1 to 4.
No. Who's next? Yes, Miss.
My lords, my lady, I appear for Vodafone. I'm going to address ground 3 first, and then Mr Pickford will also make some submissions for EE on this ground. And I'm going to start with an overview of my submission, and then I'm going to address 4 topics. And the 4 topics are the pleadings, a few short observations on the judge's findings, which the court's already seen. Thirdly, I'm going to address the 2 main authorities on which Phones for You relies, Al-Madani and Satyam, which are the 2 cases in which this court overturned first instance judgments where the judge had decided the case on an unpleaded basis. And Mr Pickford will deal with Ali and Dink in his submissions. And then fourthly, I'm going to deal with the wider evidential picture as it relates to this ground, because for reasons I'll come to, it is necessary to put the judge's findings on this point.
You're going to need to raise your voice a bit, I think, because I think the transcriber is having difficulty hearing, and I think we are as well, actually.
I'm sorry,
You're quite quietly spoken, I seem to recall. So.
not always, but
Not suggesting
maybe
everyone else is
14.
shouting, but you certainly are.
so it's pleadings, judge's findings, then I'm going to deal with 2 of the authorities, and then the wider evidential picture as it relates to this ground.
Okay.
And I just do want to flag at the outset that there's been something of an evolution of the way that this ground is put. The way that the ground was put in Phones for You's skeleton argument is this. Once the judge had found that he had certain information about Vodafone's plans in August 2014, he was bound to find that the information was obtained from Vodafone through unlawful collusion between Vodafone and EE or its parents, and therefore he was bound to find an infringement on that basis. We don't need to go there, but the references are paragraph 93 of Phones for You skeleton and 49 of its supplemental skeleton. Okay. And on that argument, the judge had 2 options, and only 2 options. He could conclude that EE had no information at all about Vodafone's plans, or he could conclude that the information in the August email was obtained by collusion between Vodafone and EE or its parents. And Phones for You's case was, those were the judge's options because those were the cases advanced by Phones for You and EE. And Mr McLean's skeleton argument, he used the phrase fork in the road, and that is a fair summary of how the ground was put. He said it was a binary issue. And in the course of his submissions, it seems to us that Mr McLean has pivoted to a somewhat different case, that absent what Phones for You calls the car phone theory, other evidence in the case might have taken on a different complexion, and the court could or might have reached a different view on whether collusion was established. And that is a different version of the ground. It's not a fork in the road point, but it instead requires a close analysis of what the judge found and where the car phone theory fits into his findings. And in our submission, it's not a surprise that Mr McLean has changed direction on this point, because it wasn't tenable to submit that the judge should have made a finding of collusion by default, in particular against Vodafone, which is what this argument amounted to on the basis of an EE internal document. And I'm going to spend some time on this part of the case, because in my submission, the court will see that on this basis, the grant ultimately goes nowhere. There are three main strands to my submission. The first is that the argument proceeds on a false premise. Phones for You says that if the judge found that EE did in fact have information about Vodafone's plans, whether it had come from Vodafone was never an issue. The parties didn't come to court to dispute that. That's paragraph 85 of Phones for You skeleton argument, which we'll go to in due course. But the premise is wrong, and the flaw in the premise is that it is based on part of EE's pleading, not even EE's pleading as a whole, but only on EE's pleading. We say Phones for You is misreading EE's pleading as a starting point, but the allegation in question is obviously not just an allegation against EE, it's an allegation that Vodafone made anti-competitive disclosures to EE through its parents. And I'll show the court that it was my client's expressly pleaded defence that if EE did have information about whether Vodafone was withdrawing from Phones for You in August 2014, that information didn't come from Vodafone. EE advanced a similar plea in the alternative to its primary case, that it didn't have any information at all, but focusing on my client's position, our defence squarely addressed the scenario in which the judge didn't accept EE's case. It had no information, and we put in issue the further question of where the information came from. And it really isn't clear what else we could have said about an EE internal email. So it's not right for Phones for You to put this ground on the basis that there was no issue about whether the information in the email came from Vodafone. From my client's point of view, that was the issue. And ultimately, the judge has upheld our pleaded defence and the equivalent plea in EE's defence. And for that reason, we say there is no parallel with the authorities on which Phones for You relies. We'll look at the cases, but they establish that a court shouldn't decide a case by accepting an unpleaded basis of claim or conversely an unpleaded defence. And that's just not what's happened in this case. The second and related strand of my submission is that Phones for You's way of presenting the issue runs together three distinct issues. The first issue is whether EE had obtained any information about Vodafone's plans one way or another by August 2014. The second issue is whether, if EE did have information, it came from Vodafone. And the third issue is whether, if EE did have information, when did it obtain it? And in particular, did it obtain the information significantly before August, at a point when it could have influenced EE's decision-making? And Phones for You needed to prove its case on all of those issues, and indeed it was the second and third issues that were critical. To prove collusion, Phones for You had to prove that the information was provided by Vodafone to EE or its parents, collusion between competitors. And to prove causation, Phones for You had to prove that the information was provided at a much earlier point in 2014 than August 2014. Phones for You accepts that. It accepts that if the information was provided in August, as the judge found, then it was too late to affect EE's decision making. That's paragraph 87 of its skeleton argument. And as we'll see, Phones for Use case has been that the disclosure took place in April and by early May. And I think that came through Mr McLean's submissions yesterday. So there were three separate issues, and the judge was right to separate them out. The content of the email only goes to the first issue, that is, whether EE had any information. It says nothing about the basis for EE's expectation that Vodafone was about to put out. And the email certainly doesn't say that EE had obtained the information many months prior to the email. And if anything, it suggests the opposite. So this is an inferential case, and Phones for You needed to persuade the judge to draw inferences from this email at two levels, both as to the source of the information, and secondly, as to the timing of the receipt of the information. And we say, faced with that case, the judge correctly directed himself in law at paragraphs 84 to 86 of the judgment. He found that he couldn't draw an inference of collusion from a document that didn't reveal collusion unless there was no plausible innocent explanation for the email. To do otherwise would reverse the burden of proof. And he also found that he needed to consider the email in the round. And we say that was the right approach in law in all of those respects. And I'm not actually sure any of that is really in dispute. So, and this isn't a question of what is pleaded or the judge determining the issues in the case on the basis of some uncanvassed case. It is the correct application of the law in circumstances where Phones for You sought to prove its case on the basis of inference from a document that didn't reveal collusion. Now, in interpreting the email, of course the judge had to consider the potential interpretations of the email advanced by the two parties contesting it, but ultimately he had to decide whether the email supported a finding of collusion. And in deciding that question, he wasn't constrained by what was specifically pleaded about the email, or whether every possible interpretation of this single email was pleaded or argued before him. He had to apply the principles in paragraphs 84 to 86 of the judgment, and that is what he did, and in my submission he did so correctly. The judge found that he needed to consider the evidence in the round, and that leads to the third key strand of my submission. As I've said, Phones for You's case is that collusion took place in April 2014, and it relies on this email to support an inference of that collusion. And the question of whether there was any such collusion was litigated exhaustively over a 3-month trial. And the court heard 27 witnesses cross-examined about this issue, including Mr Sheen, including Mr Hum, and a whole lot of other witnesses from Vodafone, EE, and its parents, Deutsche Telekom and Orange. And as the court has seen, the judge addressed the evidence going to that allegation of collusion in painstaking detail. He dealt with every strand of Phones for You's case, and he rejected it. He found no evidence of collusion. And indeed, he found evidence that was positively inconsistent with any collusion between EE and Vodafone at the relevant time, as I'll show the court. So it is simply wrong for Phones for You to say that the judge only rejected Phones for You's case of collusion in this respect because he came up with the car phone warehouse theory. It's just wrong. That is a misreading of the judgment. The judge considered the allegations of collusion in April 2014 and thereabouts on the merits, having considered all the evidence on which Phones for You itself relied, and after hearing every witness cross-examined. And Phones for You hasn't been prejudiced in seeking to prove that case. It had every chance to prove its case, and it failed to do so. That left the question of how to interpret this email from several months after the event, in August 2014. The judge found that the email contained information obtained by EE in August, and hence at a point which was too late to affect EE's decision-making. Nothing in the way the case was pleaded or argued required the judge to reach any other conclusion about this email, which did, after all, date from August. And there are clear reasons why it wouldn't reflect information from Vodafone in April, as Phones for You says, at which time Vodafone's plans simply hadn't crystallised, as Mr Pickford's already said, and I'll show the court the judge's findings on that point. So that's the timing issue. As to who provided the information, as the court seen, the judge found that it was at least as plausible that information obtained at that time had come from Carphone Warehouse, with whom EE was also dealing at that time. And for the reasons I've given in my submission, the judge was entitled to reach that view. He wasn't bound to infer collusion from an email for which there was a plausible explanation. But in any event, it's common ground that if the information was obtained by EE in August, as the judge found, it doesn't help Phones for You anyway. And there's a totally false logic underpinning the way that Mr McLean puts his case on this, which is that, first of all, the judge isn't allowed to rely on the Carphone Warehouse explanation for EE having the information, but somehow the judge is boxed in by his finding that Vodafone wouldn't have provided the information at that time. And so the information must have come from Vodafone in April. It's a totally artificial argument with respect. On the basis that the judge found that this information was received in August, it's too late, and the ground of appeal comes to nothing. So in my submission, it's critical to come back to the way that Phones for You puts its case overall. The email would only assist Phones for You if it somehow drove the judge to find collusion with Vodafone much, much earlier in 2014. And it doesn't do that as a matter of law, it doesn't do it as a matter of the evidence. When one looks at the content of the email and considers it in the context of the case as a whole, it just doesn't support that inference. And nothing in the way the email was pleaded or argued at trial prevented the judge from concluding that the email didn't support or require the inference, the somewhat heroic inference, I might say, that Phones for You sought to draw from it. So the argument simply fizzles out in my submission. So that's the argument in outline. I'll go to the pleadings next and just show the court the shape of the issue. Phones for You says that ground 3 isn't a pleading point, but obviously, as the court's seen, the pleadings are fundamental to the way that the ground has been built up. So I'll start there. If we can start with the particulars of claim for tab 21, page 517. So this is Phones for You's particulars of claim, setting out their factual narrative in relation to the negotiations between Phones for You to extend the EE agreement. And you can see from paragraph 57 that negotiations start in late 2013. And if we can then move on to page 522, paragraph 68, we can see that 68A, an agreement in principle had been reached as of late July. And the intervening paragraph set out a narrative running over that period. And if we then move on to 523 and look at 68A, this paragraph and the amendments here set out the particulars of the case of collusion after disclosure, and one can see the introductory words of 68A contemporaneously with these events, i.e. during the period during which the negotiations occurred, that is prior to August. And it says they were developing attempts to coordinate between Vodafone and its parents. And if we move then to 68E on page 524, we see that the focus shifts a bit to EE's parents' companies initiating discussions with Vodafone. You can see that in the first 3 lines. And as Mr Pickford mentioned earlier on, this is the way that the case of collusion is put. It's put in terms of collusion at parent level between Vodafone and EE's parent companies. And if we then move on to 525, paragraph 68G, this is the pleading relating to Mr Sheen and Mr Hum. Mr McLean referred to that in the course of his submissions. I'll come back to that later on. And what the court will see if you just look through these paragraphs, 68G, H, I, all of these particulars of collusion, or the particulars of evidence of alleged collusion, all relate to April. And that's consistent with the case that Mr McLean explained to the court that the collusion is supposed to have happened in this window before a change of thinking in early May. If we then move on to 527, 68K is where the email is pleaded in little b. But just going back to the beginning of 68K, it says the result of the communications between the parents and Vodafone, again the focus is on the parent companies and Vodafone, is that he was confident that Vodafone would discontinue its relationship with Phones for You. Alternatively, that if EE discontinued its relationship, Vodafone would do the same. This was subsequently reflected in EE's expectations and so on, and it says in particular, and then one sees in little b the email pleaded. So as a matter of the structure of the pleading, Phones for You pleads the collusion and evidence of collusion in the prior paragraphs, and this email is said to evidence the fruits of the collusion, what EE learned from colluding. And as I said in my introduction, the judge considered all of the prior particulars of collusion, such as the meeting of Mr. Sheen and Mr. Hum, and he rejected them on the merits. So it is a strange argument that we now have under this ground that the specific pleading in 68K must itself lead to a finding of collusion, irrespective of the judge's findings on the prior particulars. We say all of these issues clearly had to be considered in the round. That's what the judge did. And obviously one can't assess the implications of the email separately from all of the other evidence. And that's not just judicial common sense, that is the way Phones for You itself pleads the position in these paragraphs of its case. And if we then look on to 68L, I think the court's seen this, but this is the plea of a sharp change of thinking as between April and the middle of May, and I think the court's heard how Phones for You puts its case at this. So this is the window during which Phones for You says that the collusion happened. Now, if we can move on to 568. And look at, so this is paragraph 146C in the middle of the page. You can't see the 146, but you can see the C. And here, Phones for You says the timings of EE's agreement to enter into an exclusive agreement with Carphone and Vodafone UK's termination of the Vodafone's agreement are not, it is averred, coincidences, but indicate a level of coordination of activity between EE and Vodafone. And so this is the coincidence, the same coincidence that the judge identifies when he deals with this issue in his judgment. The judge drew a different conclusion from the coincidence. He didn't think that the coincidence wasn't indicative of collusion. He thought it was indicative of a different flow of information. But the reason I'm showing you this is because I want to show you how Vodafone pleaded back to this when I get there. So if we move on to EE's defence, tab 23, page 624. So this is the pleading to 68K, where the email is pleaded. And one can see in 87G there is a general denial of the allegation that EE had obtained information through its parent companies. It's a denial of the pleaded allegation of collusion. And if one then looks down at subparagraph C, little 2, one sees that EE denies that the email is evidence of an expectation that Vodafone was about to pull out. So that's the bit of pleading that Phones for You has fixated on and said this was the only issue, whether this paragraph's right. But the court's already seen that paragraph 87G more generally denies collusion. And if we then move on to 87H on 625, this paragraph pleads to 68L and the alleged sharp change in thinking based on an expectation of Vodafone's plans. And if we then look down to subparagraph E on 626, and if the court would just read that. So here EE says that it didn't have the alleged knowledge or understanding obtained from Vodafone or Vodafone Group. So that puts in issue not only whether they had an expectation, but whether it was obtained from Vodafone. So when Phones for You fixates on the earlier pleading in 87G, that is really only part of EE's pleading, even if one only focuses on EE's pleading. If we then move on to Vodafone's defence, which is tab 25, paragraph 826, sorry, I beg your pardon, core bundle 826. So here, what Vodafone's doing here is pleading to a section of the particulars which really concerns EE. So we don't engage line by line with the pleading, because quite a lot of it doesn't relate directly to us. But what we do plead in 51A1 is that we don't plead to internal consideration by EE and its parents of their strategy for their relationship with Phones for You. But we do deny that mere internal consideration of Vodafone's position is indicative or supportive of an allegation of collusion. So that's the general point, and to some extent that's all we can say about EE internal process and material. But what we do go on to say in terms in 51A2, if we could just bring that up a bit, it is we deny the allegation of coordination, and we say no proper basis for the allegations have been pleaded, and we then say it is accordingly denied that any view formed by EE or Deutsche Telekom as to the likelihood that Vodafone UK would exit from Phones for You, see for instance paragraph 68K, was the result of any coordination or collusion with the Vodafone defendants. So we directly put in issue the question of whether the information obtained in the August 10th email, which is pleaded in 68K, was information obtained by us. That's directly pleaded. And as I said, that was about the limit of what we could say about EE internal information and what its source might have been. And it seems to be some part of Phones for You's case that because EE pleaded a positive case that it had no information or expectation at all, the defendants as a group could only deny collusion if there was some other positive plea about where the information came from. And that obviously isn't right. There is obviously a burden of proof issue here because this isn't our document. But going back to first principles, the necessary ingredients of the cause of action are obtaining confidential information, strategic information, from a competitor. And we pleaded to that allegation as fully as we could, and the judge accepted our defence. Now, if we can move on to 872, please, 872, 873. So, and at the bottom of the page, paragraph 136 pleads back to 146C, which is the paragraph I showed you where Phones for You pleaded that the timing of the two decisions wasn't a coincidence. And this is our response. Here we plead in 1361 that we conducted our negotiations in ignorance of EE's negotiations with Phones for Your car phone. And then we say in 1362, well, in fact, perhaps if the court could just read that. So Mr. Pickford alluded to this point earlier on. This was referred to in the case as last man standing. And this was a positive plea by my clients that we didn't coordinate with EE. In fact, we negotiated with these parties with a view to obtaining a competitive advantage over them and in ignorance of their strategies and with the intention of mitigating the potential threats to us from our ignorance of their strategies. That was our pleaded case. And if I can just show the court the prominence that this point had in our case, we go back to 805, which is the introduction to our defence. And now, this is part of a section where we summarise our positive case in response to the allegation of collusion. And if the court looks at 5.8, this sets out the reasons why we decided to conclude an agreement with Carphone, which was an exclusive agreement and which led to an exit from Phones for You for a number of reasons. And you can see about halfway down, there's a line that says those circumstances included amongst others. And there are the terms of the Carphone deal, the apparent financial constraints on Phones for You, Vodafone UK's strategy to grow its direct sales channel and reduce its indirect sales, and then the potential and at all times independent strategies and decisions of Vodafone UK's rival MNOs and their anticipated outcomes, the perceived risk that Vodafone UK would find itself the sole MNO contracted to Phones for You, so that it was committed to a struggling indirect retailer while its rival MNOs pursued more advantageous opportunities, and the risk of losing first mover advantage in securing favourable terms from Carphone if EE did a deal with Carphone Warehouse first. So this was absolutely front and centre in our case, and with great respect to my learned friend, it was an aspect of our case that Phones for You never grappled with. They never grappled with the fact that it was all over our contemporaneous documents that one of the main drivers for our competitive strategy was that we were trying to steal a march on EE. We didn't know what they were doing, and we were trying to gain an advantage over them. And Phones for You was never engaged with that because it is really an unanswerable point in response to the allegation of collusion. But the point for present purposes is that this was a pleaded issue, and the court had to determine that pleaded issue as well. So the possibility that the information could have come from elsewhere, it was obviously relevant to our defence, it was directly raised by the pleadings, and it's common ground that it was relevant as a matter of law, as per paragraphs 84 to 86 of the judgment which the court seen. And while I'm on that point, Mr McLean says in his supplemental skeleton, the reference is tab 9, page 209, paragraph 41, that the judge needed a compelling and specific basis on which to conclude that the information didn't come from Vodafone. And this seems to be linked to the submission he made multiple times, that the email is prima facie incriminating. And in my submission, that isn't the legal framework applicable to this issue. The law is as per 84 to 86 of the judgment. So that leads to the second issue of what the judge decided. And if I can go to the judgment at 418, page 599. I'm sorry. I'm sorry. It's 427, paragraph 5. So this is the section of the judgment that deals with the email of the 10th of August. Obviously, the court's seen this. I'm just going to draw a few points out. The text of the email is at the top of 528, and if we could just scroll down to that, and I just want to observe that. It says, Neil wants to get this debt completed, the focus is Phones for You. He wants to be 100% sure of the impact if Phones for You fold earlier than expected, i.e. in the next couple of months. The expectation is that Voda are about to pull out. And the reason for focusing on that is, what it implies, just on the face of it, is that EE has new or recent information that has changed its perception of what is likely to happen. Simply reading the email, that's what it looks like. It doesn't look like it's information which goes back months and months to April. And as I'll show the court now, that's what the judge found. He found that this is new or recent information in the first part of August. If we then move on to 602, the judge makes his finding 4 lines up, that by the end of the first week of August 2014, there was at least some expectation in Mr Milsom's team that Vodafone would shortly leave Phones for You. And he says by the end of the first week of August, although it's expressed in that way, it's a finding that EE obtained information at or about that time. And that finding comes prior to and independently of the question of from whom the information came. And one can see that very clearly when you read on into 603, because what the judge asks himself is where might the information have come from? And he says, well, Vodafone wouldn't have provided information at this time because this was confidential information about its agreement with a rival. So the judge has clearly formed the view the information was provided in August, and he's then asking, well, where could it have come from in August, and that's what leads him on to what Phones for You calls the car phone warehouse theory, because this was a period during which there were these parallel relationships. And as the court seen, the judge found that the email was more likely to be evidence that E had obtained information from Carphone at about the time the email was sent. And we see from 605 that the judge didn't find as a fact that the information was transmitted in that way, but it was a plausible interpretation of the email, a plausible innocent interpretation of the email, which meant that the inferential case wasn't made out. And the judge gave at least 3 reasons for that conclusion. The first, as the court seen, is that the information was unlikely to have come from Vodafone at that time. Secondly, there were good reasons why Carphone would have provided the information to give itself an advantage in its discussions with EE. That's 604. And thirdly, the judge noted that neither party had advanced the explanation, but he thought that didn't undermine the credibility of the explanation, because there were reasons why neither Phones for You nor EE would have advanced that case. Phones for You wouldn't have said that because it would have undermined its case. EE didn't say it because that's not what its witnesses said. So that is an entirely proper application of the correct legal principles in paragraphs 84 to 86 of the judgment. And it's not unfair to Phones for You to prove that, so it wasn't unfair to Phones for You to apply those principles, the proper principles, and for the judge to conclude that the inference which Phones for You sought to draw from the email wasn't made out. And then lastly in the judgment, if we move on to 608, the judge finds in this paragraph, as the court seen in the last part of the paragraph, that if E got the information in August 2014, it was too late to affect E's decision making, and that is common ground. Now, Mr McLean referred yesterday to the permission judgment, paragraph 38, and he said that supported his submission that the Carphone warehouse theory was determinative. And in my submission, that's not what one takes either from the judgment or from the permission judgment. You've seen the judgment. The judge is clear that he doesn't make a positive finding that the information came from Carphone, but it was a plausible possibility. But if we can look at the permission judgment, please, it's tab 19, 473. And could I ask the court to read paragraphs 36 and 37? So the judge says there in terms that the Carphone warehouse theory, as it's put, wasn't determinative of his decision for the reasons I've explained. The judge found that the information was obtained too late to affect E's decision making, because he found that the information was received in August. And he goes on to say at the beginning of 38 that the question of how EE came to this expectation in early August is not therefore critical to the outcome of the case as regards either Vodafone or EE. And then what he goes on to say in the middle of the paragraph is, I do not think that a trial judge faced with a disputed inference to be drawn from the document is compelled to adopt either the inference put forward by the claimant or an inference put forward by the defendant. And that's the nub of it. That's the judge's that's the judge referring to paragraphs 84 to 86, which are the correct principles. Now, that's the end of that part of my submission. I just want to flag at the end of 38 what the judge says about Al-Madeni. He says this case is wholly different from the case of Al-Madeni. There, the trial judge had held that the defendant was liable not on the basis of the conduct of a specific employee of the defendant, as had been alleged, but on the basis of the conduct of someone else, which had not been alleged. That was obviously impermissible, since the defendant had not come to trial to dispute the claim on that basis. That really goes back to the point I make about Vodafone's pleading, we did come to court to dispute whether the information came from us, wherever it came from. So I think that's a convenient moment to break, my lord, because I'm going to go on to the authority.
Yeah, I was going to say, well, that clock's slightly slow. It's quite 5 o'clock. It's near enough. I think that's enough for one day, really.
I'm sure it is.
Okay, I think we're sitting at 10 tomorrow, but we have to rise at 4:15 tomorrow.
We understand.
So 10 o'clock tomorrow. All right,